Thank you for joining us today's webinar on DOL auto-IRA Safe Harbor Explained. My name is Hank Kim, and I'm the Executive Director and Counsel for the National Conference on Public Employee Retirement Systems. Today's program is part of our Center for Online Learning. The purpose of NCPERS Center for Online Learning is to provide remote continuing education to public pension trustees, staff, and other fiduciaries and stakeholders. In today's webinar, we will discuss the recent final Department of Labor's regulation on state-sponsored retirement savings plans for the private sector, as well as a proposed rule for municipal-sponsored retirement savings plans for the private sector. Leading us in today's discussion is Mr. David Morse, partner at the law firm of K&L Gates. Mr. Morse's practice areas include employee benefits, ERISA, and tax. He has been NCPERS ERISA and Secure Choice Counsel since 2011. As always, we encourage you to submit written questions and comments. Written questions and comments can be submitted by using the GoToMeetings dashboard. However, in order to get through the presentation, we will hold all questions and comments till the end. We anticipate the prepared portion of today's webinar to last about 45 minutes. Additionally, today's presentation and other supporting materials are available in the handout section of the dashboard. At the conclusion of this webinar, we will ask you to take a short 3-question survey. We highly encourage you to take a minute to take the survey as it informs our future webinar experience. David, with that, let me turn it over to you.
Okay, thank you very much, Hank. Appreciate it. Just to set the table for what we'll be discussing today with the final DOL Safe Harbor, what's been happening over the last several years is the states have recognized that there's this growing gulf in how much employees and their citizens have saved, prepared for retirement, and compared to what they're going to need. And there's been really not much happening in terms of a federal solution. So the states have been exploring various alternatives that they can do to at least try to help things amongst their own citizens. And they've been taking a 3-pronged approach. I mean, the simplest form is to create what's called a marketplace, where it's essentially a website that the state would establish, and it would go to be a place that employers could go to if they were looking to set up a simple retirement plan where they could find vendors and compare products and all that. I should say, just to start, that it's been recognized just everywhere with economic studies and social studies, and the states have commissioned their own analysis, is that if folks are much more likely to be prepared, or at least somewhat prepared for retirement, if they're participating in some kind of retirement plan. I think we all know defined benefit plan would be the preferred approach, but even some sort of 401k or other defined contribution plan goes a long way in helping people take a step. So what they're really trying to encourage the states is they're looking at the people who are on the bottom of the retirement ladder, who are working for a company that doesn't offer any plan. So the first prong, as I said, would be the marketplace. The second prong that that states have been looking at is to establish sort of a cookie cutter program that any employer within their state could join, called an open MEP. MEP standing for a multiple employer plan. So it would be usually a 401k kind of plan that an employer within the state would just fill out some forms, and everything else would be their turnkey, because it would be created by the state, with hiring record keepers and money managers and that sort of thing. And then finally is something that's been called an auto-IRA, and that's being considered by a number of states. Actually, 5 states have passed enabling legislation: California, Oregon, Illinois, Connecticut, Maryland. I think I got everybody. And that type of program, and that's really where the focus of the DOL reg would be to create an auto-IRA, so if an employer joined, that is, its employees would automatically be enrolled in this just very simple IRA program and would have money withheld from his paycheck, and it would go into an IRA into his or her own name and be invested for him. I say that none of these programs yet, even the marketplace, which is the simplest of the concepts, has gone live yet. We're hoping maybe by the end of this year there should be a marketplace or two that are operational, and maybe by sometime next year there should at least be one or two of these auto-IRA programs up and running. The states that have at least passed legislation to create these open IRAs, their programs, I mean, they're all a little different, but they do follow a common framework. And first of all, they have an employer mandate. They have a requirement that any employer that employs workers within their state that meets certain requirements has to join and make available the IRA program to its workers. The first requirement that the states are imposing is that the employer doesn't offer any other retirement plan. So no defined benefit plan, no 401k, no 403b, nothing for their employees. And these, as I said before, are the workers most at risk. Additionally, states will have a requirement that the employer must be a certain size. California, it's 5. Illinois, it's 20. I mean, each state has a different way of establishing it. But once you meet that minimum threshold, what the state law is saying is that you must make our auto-IRA program available to your workers, unless you go out and adopt your own 401k plan. And interestingly, New York City Controller's Office, which just released a good 80-page report studying all the different alternatives available, is actually recommending that states consider a three-pronged attack, that do all three: have a website, develop an open MEP, and have the auto-IRA as the last fallback. The other part of these auto-IRAs, of course, is that employees are automatically enrolled in the program and contribute at a fixed rate, which is usually set in the statute, somewhere between, let's say, 3% and 6%. Of course, the worker has the right to opt out of the program or any time, not contribute, or to elect to contribute a different amount. But what the states have all found, and this is also
Hello, David? David, are you still on?
Yeah, I'm on. Are you on?
Yeah, you blanked out for a while.
Really? When did you lose me?
Just about, I'd say 30 seconds ago, and I think you were just talking about, so you just talked about the cocktail approach of that the comptroller of New York City suggested, and then a few sentences, and then you blanked out.
Oh, I'm so sorry. At least it looked okay from my end. So what the states have found is, I was just talking about auto-enrollment and how these programs work. It's been established in the private sector that when you auto-enroll someone, in other words, you start contributing, taking money out of their paycheck and contributing it to an IRA or a 401k or anything, that folks are much more likely to save. The powers of inertia and just framing, just like if it's happening, we'll let it go, allows workers to save a lot more, and including low-income workers who actually find that they can get by with 3% or 5 or 6% less pay. Again, always with the ability to change or stop contributing at any time. So with that as background, the states recognized that they needed their auto-IRA programs to be exempt from ERISA coverage for these programs to work. The most important feature was ERISA preempts all state laws that relate to employee benefit plans. And the fear was that a state that had an employer requirement that they make the auto-IRA program available would be preempted by ERISA. But if the auto-IRA program wasn't considered an ERISA plan, then the odds of the state mandate being preempted by ERISA are much, much smaller. I think really the states have an excellent argument that there should not be ERISA preemption of their auto-IRA programs, as long as the programs themselves aren't viewed as ERISA plans. Now, the Department of Labor had a position really from the day one of ERISA that certain payroll withholding programs weren't considered ERISA pension plans. And I'm using the word pension plan, by the way, in the ERISA sense, any sort of retirement program. And the ERISA standard of what's a pension plan is generally very broad. But the Department of Labor issued an exemption way back in 1975 that provided that if a payroll withholding program where the employer really doesn't take any action except make the program available to its employees. So say, hey, here's Fidelity. If you want to contribute to their IRA, go talk to Fidelity. And the only thing the action that the employer would take in those kind of programs is besides making the program available, hand out materials and withhold if the employee elects. The Department of Labor has said those kind of programs aren't considered ERISA pension plans. And those things happened also not only with IRAs, but with life insurance, disability insurance, AFLAC-type products, where they, as long as the employer involvement was minimal, it wasn't considered a pension plan. But the DOL has a lot of problems with, or at least concerns, with programs that offer auto-enrollment. And the DOL had been saying that a program that has auto-enrollment of workers would be covered by, or would be an ERISA plan, would be covered by ERISA. They were concerned that there was just too much potential for employer abuse with a program that had auto-enrollment. I think personally that they were being too conservative, that it's a pretty common thing in the for-profit world with 401ks, but they were concerned about it. So the states went, and NCPERS was actually very helpful in this, a big part of this. They went to the Department of Labor and said, we need an ERISA exemption for our auto-IRA programs. And lightning speed for the Department of Labor, they proposed regulations last year, and the regs were finalized the end of this summer. And I'll go through the requirements to come up with the DOL safe harbor. And these only apply to, at the moment, state-enabled auto-IRA programs. There's also, and I'll discuss towards the end of the program, the DOL is considering extending it to cities and other local governmental entities that they could create their own IRA. So when I say state, just have in your mind that it could also include a city or a county or some other larger governmental unit. The first requirement for the DOL safe harbor is that the program must be established under state law. There must be a state enabling statute. Importantly, in the final regulations, the Department of Labor made clear that a state could delegate a lot of the nitty-gritty requirements of their program to a committee or a board. How the programs that exist now, or at least being developed now, all operate is the state appoints a board that's going to actually create and administer the plan. And the board is usually picked from someone from the treasurer's office, or maybe the state treasurer himself, and some other appointed members representing workers, employers, unions, and the like. And it's very important that this board have the flexibility without having to go back to the legislature to craft their program, because in the designing these auto-IRAs, you're finding that, well, it's growing as time goes on, is that thinking about, all right, what's feasible, what kind of record keeping can we handle, how are we going to roll this out, and you really need a lot of flexibility. I mean, think about the 529 plans, which is probably the most analogous, that for college savings, that the states, they created those out of almost whole cloth, and those programs have developed over time as they've grown in size and scope, and you learn. Each state learns from the others. They learn from administering programs, so they really want that flexibility. The second requirement is the program has to be administered by the state or the board, which must be responsible for investing employee contributions or selecting investment alternatives. So far, where the states have their auto-IRA programs under development, they're looking at either some sort of life cycle fund where everybody would automatically be invested in that with no employee choice, or maybe a choice of a couple of very basic investments, maybe something very safe, low risk but lower return, and then maybe an index fund. In addition, as part of this, the Department of Labor made clear that it's fine if the investment handling from the selecting the investments or the asset allocation or whatever can be delegated by the state or the state board to a private sector party. As long as the state board is sort of sitting on the top of the food chain, if you will, and is responsible at the end of the day for selecting and monitoring, and if something goes wrong, the department is very comfortable with them outsourcing the whole functions. And indeed, with the programs that are in development now, that's the approach that every state is contemplating, that they're going to hire a record keeper and consultants and money managers to handle the program. The third requirement is that the state must assume responsibility for security of payroll deductions and employee savings. And actually, that was a direct quote from the regulation. That's kind of awkward wording, and it also appeared in the proposed regs, and the states had commented that it almost made it seem like the states had to guarantee the success of the IRA program. But the DOL made clear in the final regs, in their preamble to it, is that they're not trying to create this strict liability standard, and that they just wanted to make sure that the states would have some sort of investment mechanism, so if somebody's employer withheld money from a worker's paycheck, that the money actually makes it to the IRA program. And the department said that in most cases, a state's existing wage withholding and theft laws, which I believe all 50 states have some version of, would be enough to satisfy that requirement. And then they certainly weren't expecting the states to guarantee that the employer's conduct, or more importantly, the investment return on this. If a state wanted to, they could also, instead of using their existing withholding laws, they could adopt a special role just for their auto-IRA programs. And the department encourages the states to adopt reasonable consumer protections to make sure that the employees' money made it where it was supposed to be. But the department is taking a very flexible approach on this. And I think that's, again, something there to be commended for, actually, because they were very, very cooperative in crafting a final reg that will give the states a lot of room to move and create a good program. The fourth requirement, and this, by the way, these numbers are my numbering. The Department of Labor kind of split things up in a not necessarily completely logical way. That the states must have a mechanism for enforcement of employee rights under the program. I think that's actually already subsumed with the wage withholding laws, and plus existing state laws and a court system would be sufficient to take care of this. And of course, every state has a court system, and if someone gets screwed or thinks they've been shortchanged, they can certainly sue under state law. The fifth requirement is that the program has to be voluntary for employees. I'll get into that a little bit more, but for now, just recognize that the employee has to always have the ability to decide how much, if any, he wants to contribute to the IRA. The proposed regs had a requirement, which the DOL fortunately took out of the final regs, that that the states, if they wish to now, can impose restrictions on withdrawals from the IRA. The normal tax rule for an IRA is, as you know, you can go to the bank or mutual fund and take out your money at any time you want. There are no restrictions. You might have to pay an excise tax, and you'll have to pay income tax, but you can do whatever you want with it. You can treat it almost like a bank account. And some of the states were really concerned about trying to cut down on what's called leakage, which is, people just dipping into their retirement savings for not for emergencies, but for just regular old consumption. And if the state wants to now, they can impose, for example, a hardship requirement that prior to, I'm just making this up as an example, but prior to age 60, you can't withdraw from your IRA unless you have hardship. This also, being able to impose withdrawal restrictions, will allow some states, if they want to invest in long-term investment vehicles that may have a penalty for early withdrawal. Would also allow a state, if it wants to annuitize, provide someone's IRA account, that the state, if it wanted to, it could provide that all balances above a certain amount will be used to buy an annuity contract and pay someone out over their time so they can't run out of money. It also would allow certain guaranteed return products that are available where they're equity-based investments, but the upside in potential is sort of capped, but there's a guarantee that you'll never lose money as long as you let the money remain in the IRA long enough. So that again gives the states the flexibility to choose what's best for their citizens. Next requirement is the participant's rights must be enforceable only by the participant or his or her representative or the state. That's a pretty easy requirement to meet. I'm never sure why the department even mentions that, because who else is going to enforce it except the individual? or his attorney or power of attorney holder, or the state would have obviously enforced their own rules. The next requirement, which is very important, is that the employer's involvement in the program has to be limited to ministerial acts. They don't want the employer to have any discretion in determining, how the program will operate or what happens with employees' money or whatever. So things like the employer can hand out brochures about the program or information about where to go. The employer obviously has to be part of the payroll processing and make sure that the money gets withheld from employees' wages. Record keeping and registering for the program. I mean, how I believe most of these programs will end up working is a covered employer will register its employees with the state auto-IRA program. So say, okay, I've got employees A, B, C, and D. This is their name, address, date of birth, and social security number, and go contact them and work out how they can make their elections and just let the employer know, or probably more to the case, let the employer's payroll vendor know. So those kind of connections are fine. What they don't want is the employer to have any discretion to choose investments for their employees, to contribute, to encourage their employees to contribute. And in fact, if the employer wants to, it can't contribute its own money to these auto IRAs. The employer really has to sit on the sidelines. And you can see this is sort of the simplest, most basic form of retirement program. I think as Hank has called it, it's sort of taking baby steps here. The next requirement is the employer can't get any sort of windfall or reward for participating in the program from the state. The state, if it wants to, could give employers a tax credit to cover their cost or the average cost of setting up the correct payroll system. That's fine, but they don't want to have the states enticing employers beyond just covering their costs to incentivize them to participate in the program. Again, I think that goes back to the Department of Labor's somehow fear that employers, if they have too much at stake here and it's not regulated by ERISA, will somehow abuse their powers. And in the regulations, the department made clear that the states can really have a lot of flexibility in choosing which type of employers can be subject to the state mandate. So I had mentioned before, all the states that have passed enabling legislation would provide that an employer above a certain size that doesn't have a plan at all would be covered by the mandate. But some states are also considering, even if the employer has a DB or a 401k plan, that any workers who are not covered by that plan, let's say because they're part-time, the state could also mandate that those uncovered workers would also participate in the auto IRA. It's really the Department of Labor is saying, hey, states, you take full responsibility. You decide what's best for your particular citizens. And now we last really get to the most important requirement from the DOL's point of view, which is the auto enrollment. And as I mentioned before, the DOL was concerned much more so than, let's say, the SEC or the IRS is about auto enrollment becoming some sort of employer abuse. So for a program to be qualify for the ERISA safe harbor, in other words, to not be covered by ERISA, and have auto-enrollment, the auto-enrollment feature must be required by state law, and there must be, of course, adequate notice to employees in advance so that they know what's going to happen and that they can act out. And there must be an employer mandate that the employer make the auto-IRA available to its workers. And you can only have auto-enrollment if only on those employees that are affected by the state mandate. So an employer who just likes the state program and say, hey, it's a good program. I mean, we have a DB plan, but we want to make this available too. The employer could do that, but only if the auto-enrollment of employees didn't cover that particular employer's workers. Once auto-enrollment is implicated, then you've got to have the mandate. And I should say, if you don't meet the requirements of the Department of Labor safe harbor, it's not that the world ends. It's just that that particular employer has now created an ERISA pension plan that's covered by all of Title I of ERISA, so all the fiduciary rules, the reporting rules, the disclosure rules, the funding rules. It's just a full-blown ERISA plan. It doesn't mean that it's an ERISA. It's a pension plan for purposes of the tax code. As far as the IRS is concerned, the employees still all have their own individual IRA accounts. But on the other side, that particular employer has now created an ERISA plan. But it's important that the DOL in the safe harbor, it provided that a particular employer's losing the safe harbor doesn't affect anyone else. The taint doesn't spread. So that employer has an ERISA plan, but it doesn't affect any other employees, and they would still be able to take advantage of the exception. So the state, in crafting their auto-IRA programs with just careful drafting, can just make sure that it's clear who's covered by the mandate and which employers or which workers aren't, and making sure that the workers who aren't covered by the mandate don't have auto-enrollment. So one question that came up with a lot of commentators and states for the proposed reg is like, okay, well, what do we do if some employer is covered by the mandate, but then 3 workers leave and said they don't meet the size requirement anymore? There was a 20 employee minimum, and now this particular employer has 17 employees. Do we lose the safe harbor right away, at least for that employer? And the answer depends upon how the state rules work. If that particular employer, according to the statute and the state board's rules, is still covered by the mandate, then the safe harbor will still apply. So, for example, a board could create their program. They say, okay, if you drop under the minimum threshold of number of employees, you'll be covered by our state mandate for the rest of the year or for the rest of the quarter. Or the workers who are currently enrolled stay in the auto-IRA program, but all your new hires until you reach the threshold again aren't. It's really up to each state to craft its own program. But once the mandate doesn't apply to a particular employee or all of its employees, then those employees would have to would have to lose their auto enrollment, and they would have to actually re-enroll voluntarily, either by calling up or filling out an online form or even a paper form. I think the Department of Labor is being rather conservative in this case, where we're basically taking someone who's been happily saving through auto enrollment and saying, hey, now you got to take affirmative action. And every study in the world that's been conducted on all this shows that folks are much more likely to save if they're auto enrolled, and that what you make people have to take affirmative action on their own, you just lose a lot of people. They procrastinate. They just say, oh well, I could use the extra bit of compensation for the next few months. I'll do it after my anniversary, after Christmas, after whatever, and then they end up not saving. But that's kind of the world that we're just required to live with at this point. But the key features, though, of these auto-IRA programs, and why I think once they start going live, they will be effective in getting folks to at least start saving for retirement, is because of the employer mandate and the auto-enrollment. The employer mandate, because it's just been shown that workers are so much more likely to save if they have some kind of program at work. They just don't do it on their own. I mean, any employee can go to Vanguard or T. Rowe Price or wherever and set up their own IRA, but a lot of people don't do it. And then auto-enrollment is just incredibly successful in getting people to save. And especially the two features, that having a workplace plan and auto-enrollment, have been shown to be really incredibly effective with the lower paid workers, the folks that you're most worried about in not saving enough or not saving anything. And that's where a lot of the benefit of these programs are going to come through. But at least at the moment, the Department of Labor is just adamant that you can't auto-enroll employees without this state mandate and having the state or the state board or some sort of organization supervising the program and there to protect the workers' interests. They just don't trust that the employers will always act honorably in this. Again, I think that the DOL is too conservative, because I don't think employers have this great desire to force trick their employees into saving. I mean, there's no real scheme here to hurt anyone or even potential. At the time, I think that covers the gist of the DOL safe harbor. When they issued the final regulations, the department also issued a proposed regulation that would allow cities and counties and other governmental units to also establish an auto-IRA for their citizens. The requirements for a city, I'll just say city to make it easier for conversation, to be able to do that. First, there can't be a statewide retirement plan in that particular state. And that's language is actually a bit troubling, and the Department of Labor has gotten a lot of comments on that already. It's not clear what it means. Does it mean that the state has an auto-IRA program, or would it count if the state had simply a shopping network, a retirement plan marketplace, which really isn't a program? A lot of commentators think that just by virtue of the fact that a state offers a marketplace, electronic marketplace, that would be enough to prevent a city from offering an IRA program. I'm not so convinced that's what the DOL meant, but just because there's enough uncertainty there, it's something the Department of Labor is going to have to explain for us. The other requirement at the moment is that the city has to be at least as populous as the state with the lowest population out of the 50 states, not including D.C. At the moment, that's Wyoming, which has just a shade under 600,000 citizens. So cities like New York City or Boston or Seattle actually doesn't make it, would be able to offer a program. Now the DOL is kind of asked for comments on that, and what they're trying to do with the size requirement, they just want to make sure that the city has enough of a heft to run an IRA program, that they can just handle it. Although I question whether a small city that would really want to take that chore on, if they weren't very comfortable they could handle it. The DOL is thinking of instead offering, having a requirement that the city to demonstrate that it has the sophistication to run a program. So if the city or the county runs their own retirement plan for their own workers, a DB plan, a 457 plan, anything above a certain size, maybe that would be the requirement. Maybe they would have a dual requirement, a certain minimum size, and then also demonstrating that they can run their own program. That's to be continued. We'll just have to wait and see what regulations the Department of Labor comes up with when they finalize the regs. I understand they're trying to do it in this administration, just to have a clean deck for the new president. So we'll see. I mean, they've been really moving at rapid pace for now, and I think that about sums up what I've got to say on the new Department of Labor Safe Harbor. And Hank, ready for some questions when you are.
Great, thank you, David. So we have a couple. So the first is you talked about that. While a number of states have passed legislation and they're getting the program up to speed, that none are up and running. When do you anticipate the first one to be, and where do you think that's going to be?
I'm thinking that Oregon seems to be the state that's furthest along, and I know they're hoping to have it up by mid-year next year, and I know they're working very hard to have that done. So that would be my guess. I think I think most states will be rolling it out slowly. They don't want to have they want to make sure everything works and make it as easy as possible for employers, so that they'll probably roll it out for the largest employers first and then gradually scale down to the minimum size. Because especially for employers that don't already use a payrolls vendor and have electronic payrolls, it will be a bit of a startup for them to get ready to participate in one of these.
And you kind of alluded to the next question, but in terms of sort of hiccups or bugs to work out, what do you think, or what are state studies showing as to be the items that folks ought to be concerned about as they roll out these programs?
It's really the inner plumbing, just making sure that the employees get enrolled and the money gets withheld and gets to the right account. But this is something that the large vendors are very familiar with. So I think there already are 401k plans, and that the difference here is just communicating to employers about what they have to do and making it pretty easy for them, because this is really not tended to be any sort of burden on employers, and it's not supposed to create any real cost for them. But these kind of mistakes, though, and there always are mistakes. Every 401k plan has errors during the year. Are the kind of things that can get corrected pretty easily, so that. And I think the states will build in an infrastructure for employees to have complaints, for employers to go to with questions, and for resolving anything that goes wrong. So I hope that answered the question, Hank.
I think so, if I understood it correctly. And then sort of the final question that I have is, you know, just recently, within the last week or so, there have been a commentary or two by folks who allege that, this is the first step towards, states, either subsidizing public plans or, that somehow, the assets are going to be of these state-sponsored retirement savings programs for the private sector somehow being, used by the state for other purposes. Can you talk about, how these, how there is a wall separating, these retirement accounts from, the state or localities retirement systems for the public sector, and B, how these assets cannot be used by states for other purposes?
Okay, sure. That's one of the chief criticisms lodged against these programs, Hank. So first of all, it's not a defined benefit plan. It's a defined contribution type plan. So the program can't be underfunded or overfunded for that matter. Each employee's benefit is going to be what's in his or her own IRA account. Second, the states that are working on it now each have independent boards, granted appointed by various government departments, including the governor and the treasurer and their house or their legislature. But an independent board that's taking their responsibilities very seriously and really is not simply an alter ego for the state, and they're building in investment guidelines and that sort of those sort of protections. And under state law, they'll still be a fiduciary, and they can't just take that money and use it for government purposes, let's say. And there's a lot of transparency that's also being built in, that employees will know where their money is going, what's it being invested in, and really all the states are looking at are mainly some variation of index funds. I also should have mentioned early on is that a couple of states, including California, are looking at using the federal government's MyRA program for the initial investment. The MyRA is basically a regular IRA, but that is invested in sort of a blended fund of the average of all the Treasury yields from 1 year to 30-year certificates, and currently is paying like 2-point-something%, which these days is pretty good. So that's another investment alternative that they're considering. And each of the states enabling legislations, they all provide that there can't be any, going to the other way around, there can't be any state guarantees, there can't be any state liability or subsidy for these programs. These programs are being designed to fly on their own, and I don't think any state has the will or the funding or anything else to be subsidizing retirement benefits for its private sector workers.
Great, thank you, David. That's all the questions we have from the chat. So, David, again, thank you for your time and your expertise and your efforts in furthering retirement security to the private sector. And I thank everybody on this webinar for your participation. Again, I encourage you to take a few minutes to take the survey at the end of this webinar. And we look forward to seeing you at the next NCPERS Center for Online Learning event. Thank you.